praises, all praises due, but now it's hell. I need some help. What you got for me? Alright, here we go. This is a docket. You know what I'm saying? Here we go. I'm gonna read this for you. Forgive me for any mistakes if I make any. Before we can proceed any further with this matter, as director and beneficiary of my legal person corporation, the attorney have 10 days to respond in writing and provide proof of claim with evidence that he or she has legal and lawful authority as my public servant. My honor, can you ask the attorney for James B. Nutter, does he or she have first-hand knowledge that can be submitted under affirmation of penalty of perjury that he or she is the public servant for the defendants of the Howard Raymond Stellmarker estate and the heirs of the estate, or if he or she is acting as he or she is the injured party, can the attorney present the injured party to be sworn in under affirmations of penalty of perjury? Federal Rules of Civil Procedure, Rule 17, Plaintiff and Defendant Capacity, Public Officers, a real party in interest, designation in general, and action must be prosecuted in the name of the real property in interest. The following may sue in their own names without joining the person for whose benefit the action is brought: an executor, a minister, a guardian, a bailee, a trustee of an expense trust, a party with whom in which name a contract has been made for another benefit, and a party authorized by statute. Minor or incompetent person. With representative, the following representatives may sue or defend on behalf of a minor or an incompetent person: general guardian, a committee, conservator, a like fiduciary. Without a representative, a minor and an incompetent person who does not have the duty appointed representative may sue by the next friend or by a guardian or ad litem. The court may appoint a guardian ad litem or issue another appropriate order to protect a minor or incompetent person who is unrepresented in the action. Howard Stellmarker has deemed to have dementia. Cite Dr. Spellman, VA, West Haven Hospital. Rule 25. Substitution of parties. Death. Substitution of a claim is not extinguished. If a party dies and a claim is not extinguished, the court may substitute the proper party. A motion of substitution may be made by a party or by a descendant, successor, or representative, or an motion is not made within 90 days of service after statement noting the death. The action is against the descendant must be dismissed. However, to remain in honor, I conditionally accept all claims upon proof of claim and return for discharge the debt of the unilateral note, i.e. contract, concerning the Federal Reserve debt note created in the Howard Raymond Stellmarker estate. My honor, can you have the attorney for the opposing party present James B. Nutter's consideration for the record? I have never been presented with any sworn affidavit that will provide validity of your assessment. It is my best and considered judgment that no such paperwork or affidavits exist. So you consider, you know what I'm saying, should you consider my position in error? However, you can clearly see that Tor English Law, CEO Papadopoulos LLC, on the summons, see addendum, file number attached. It is my belief that James B. Nutter and Joseph R. Dunay are attempting to extort the Howard Raymond Stellmarker estate through fraud, as if they gave consideration for the real property and trading colorable money for real equity, violating Title 18, 241, and 242. U.S. Title 18, U.S. Code 1001, Statement of Entries, except and otherwise provided in this section. However, in any matter within the jurisdiction of the executive legislation of the judicial branch and the government of the United States, knowingly and willfully falsifies, conceals, or cover up by any trick, scheme, or device, material, fact, make any material, false, fictitious, or fraudulent statement or representation, or make or uses any false writing or document knowing the same to contain any material, false, fictitious, or fraudulent statement or entry. Federal Reserve notes is colorable. Federal Reserve notes is a colorable dollar as it has no substance in common law jurisdiction. The contract would be unenforceable. Colorable money, colorable courts. The word colorable means something that appears to be genuine but is not. Maybe it looks like a dollar and maybe it spins like a dollar, but is not redeemable for lawful money, silver or gold. It is colorable. If a Federal Reserve note is used in the contract, then the contract becomes colorable contract. And colorable contract must be enforced under colorable jurisdiction. So creating Federal Reserve notes, the government had to create jurisdiction to cover the kinds of contracts which use them. We now have what is called statutory jurisdiction, which is not genuine. Admiralty jurisdiction, it is colorable admiralty jurisdiction. The judges are enforcing some because we are using colorable money. Colorable admiralty is now known as statutory jurisdiction. Compelled benefit. I believe the benefit being used is that we have been given the privilege of discharging debt with limited liability. Therefore, there is no substance in Federal Reserve note. It is worthless paper given in exchange for something of substantive value. Congress offers us the benefit that money created by the Federal United States can be spent all over the continental United States. It will be legal tender for all debts, public and private, and limited liability is that you cannot be sued for not paying your debts. When we use colorable money to discharge our debt, we cannot use the common law court. We can only use a colorable court. We are completely under the jurisdiction of a uniform commercial code because we are using non-redeemable negotiable instruments and we are discharging debts rather than paying debts. Remedy and recourse. Every system of civilized law must have two characteristics, remedy and recourse. Remedy is the way to get out from under the law. Recourse is you have been damaged under the law. You can recover your loss. Common law, the law of merchants, and even the uniform commercial codes have all remedy and recourse. It took us a long time to discover where the remedy and recourse are found in the UCC. They are found right in the first volume, 1207 and 1103. Now, UCC 1308 remedy, the mark of the valid reservation of the rights preserved, whatever rights the person then possesses, and prevents the loss of such rights by application of concepts or waiver of or estoppel. UCC 1207.7 in parentheses is 1308 without prejudice or under protest. As a secure creditor of the Howard Raymond Stellmacher estate, I move to discharge all debts with my rights to equitable relief in Connecticut Practice Book 10-27. As an intervener, I move to discharge the debt according to the right to set off the debt as a third party and pleader. You may just want to cut your losses and be done with me, especially if you think that collecting from me will be difficult. Therefore, many jurisdictions by statute or by case law have established a mechanism for discharging even a liquidated and undisputed debt. In such a case, carefully follow the procedures established in your jurisdiction in order to effectively discharge the debt. Alright? And then you see it, Toy English Moss, Bridgeport, Connecticut, phone number, Sir Juris. Certification. You know what I mean? And that'll cover that for now. And I'm going to come back at you with this other video, you know what I'm saying, that's going to show you how all bank frauds are loans. All bank loans are frauds. Alright? So yeah, you know what I'm saying? Stick around, you know what I'm saying, and look for your boy because it's coming to you real soon. You're one. Presentment of conditional acceptance. As a beneficiary of the Howard Raymond Stellmacher estate, authorized representative, I move to rescind the note on the grounds of failure to perform. According to the note, Howard Stellmacher produced the note, and James B. Nutter is attempting to mislead the court with fraudulent documentation as if they gave Howard Stellmacher anything, when in the summons itself states that he gave permission to execute the actual cash value to fund the bank loan check. I move to pay in full with the money account of the United States upon proof of claim of the following conditions: validation of the debt, the actual accounting, verification of their claim against me, a sworn affidavit, or even just a signed invoice, a copy of a conditional binding, a copy of a contract binding both parties, when I will be happy to pay, then I will be happy to pay any financial obligation with the money account of the United States I might lawfully owe as soon as I receive these 3 documents. Alright? Alright.